that the election of directors and the vote on other matters can be held. A shareholder does not have to attend the shareholders meeting to vote. They can do what's called a proxy. A proxy is simply a person or entity that's standing in my place. Yeah.
Oh, really? Oh, okay, thank you.
They usually do it, so I'm kind of surprised. Great. That's great. Okay, so we're good. Thank you, Alex. So shareholders can vote by proxy, right? What that means is a card, a written card that will have the names of the directors who are being voted on and any matters that are going to be decided. And the shareholder, instead of having to fly to New York for the annual shareholders meeting, can sign the proxy card saying, I, as a shareholder of 10,000 shares, would like my votes to be counted as thus. For director number 1, yes. For director number 3, yes. For director number 4, yes. Regarding the resolution, do we merge with Alcoa? No. That's my vote for the annual meeting, right? So I don't have to fly to New York to personally attend. I can fill out a proxy card, mail it in, and that will constitute my vote. Make sense? Voting requirements. At least one class of shares of the corporation has to have voting rights. Usually that's who? What type? The common shares, right? Preferred shares usually do not have the right to vote. The preferred shares get all kinds of other preferences, but they usually cannot vote unless it's something major like a merger. Or do we dissolve? Now, how do we decide what shareholder gets paid? Or gets to vote? Or gets to make the decision? We do what's called a record date. So, whoever the shareholder on the record date, it can't be more than 7 days before the shareholders meeting, has the right to vote, right? So let's say the record date is February 1st. And we're going to have the meeting within 70 days, right? Right? So let's say March 25th is the date of the annual meeting. Okay? Record date. So what do we mean? All shareholders who own shares as of this date will be considered record date shareholders. When we have the annual meeting on March 25th, if you are a shareholder as of this date, you get to vote. Okay? The corporation has to prepare and maintain a shareholder list available for inspection by the shareholder. And the reason for that is so that if I'm a shareholder and I want to try to get other shareholders to vote the way that I want a particular matter to be voted on, I can get the list of shareholders, which contains their names, addresses, how many shares they own, so that I can maybe petition them. Say, hey, Robert, you vote on maybe shares in XYZ. They're going to decide, hey, it's not good for us. You agree? You might not, right? But if you do, I can say, let's agree to vote no on this. Corporation has to make that list available. So that I, as a shareholder, owner, can kind of petition other people who might be like-minded to vote the way I want them to vote. Yeah. Right? Because on the record date, the board is shareholder. Yeah. Same with dividend. Y'all slip a little bit ahead. The same happens with the dividend. On the record date, when the board of directors says, we declare a dividend for the second quarter, for the first quarter, The dividend will be paid to all shareholders who are shareholders as of the record date. So if I, on the record date for a dividend, if I own 10,000 shares on that date, and the dividend is declared, and it will be paid on March 25th, okay, I can sell my shares on February 2nd. Completely sold. I'm entitled to the dividend that I would have gotten, that I got, because I owned on the record date. Who said that? The record date establishes when the dividend will be paid, who the dividend will be paid to. It will be paid to all shareholders who own shares as of this date. Doesn't matter if I continue owning the shares or sell them. That doesn't matter. If I own them on this record date, I'm entitled to the dividend when it's paid. That makes sense? So the same with voting shares. If I'm a shareholder on the record date, I have a right to vote at the annual meeting, whether or not I sell my shares after that time. Okay? I'm probably not going to bother to vote if I sold my shares because I don't care anymore. I'm no longer an owner, right? At least that's the idea, right? But in the case of dividends, people do that all the time. So if the shares are skyrocketing in value, I want to take that value, right? I can sell my shares and still get the dividend because I was an owner at the time. Okay? A quorum. This is interesting. So what's the word quorum mean? Yeah. There's an opposite word that is actually used. It's the majority of the body. That's what the word quorum means. A majority of the body. But it does mean the minimum number required to get something done. So let's say in our situation where we've got authorized shares, 10,000, right? I need you guys to follow me on this, okay? So we've got 10,000 shares authorized in our articles of incorporation, right? We've issued 6,000, right? We put 6,000 that we sold, and we've got 6,000 outstanding. That's how many have been issued, right? Yes? All right. At some point down the future, we buy back 6,000 or 2,000. They become what? Treasury, right? So now we've only got 4,000 outstanding. 4 and 6, 4 and 2 is 6,000 issued. With me so far? Yes. Watch this. Alright, what is a quorum? A quorum is the required number of shares that must be represented in person or by proxy to hold the meeting. If we can't get a quorum, we can't even hold the meeting. So, when we do our annual meeting, all the people that are going to show up, okay, and we do a head count. Right? And we head count not just people, but shares. How many shares do we have available? We do a head count. Okay, Allison has 10,000, Robert has 50,000, Aline has 100,000, Joseph has 20,000, what's your name? Tina has 60,000, whatever. We count all of that up. We get all the proxy cards. We count up the shares on that. And then we see if we have a quorum. If we have a quorum. Once the quorum is present, withdrawal of shares has no effect. And the affirmative or yes vote of the majority of the voting shares represented at the meeting is an action that's been approved. Watch how that works. 4,000 shares are outstanding. That means these 4,000 shares can vote, right? What's a quorum? What is the majority number, the minimum number that makes a majority out of 4,000? 2001, right? So let's say we add up all the shares, we count up all the proxies, and we have exactly 2001 shares available at the meeting. Do we have a quorum? Yes. So we can move forward, right? If we had only 2,000, we couldn't have the meeting. No quorum. Quorum is a majority of the body, right? 2001 means we've got a quorum. We can have the meeting. We can vote, right? So now when we do the vote, let's say the vote is to merge. Here's the question. Do we or do we not merge with XYZ Corp? We are ABC Corp. And the question before the shareholders at the meeting is, do we merge with XYZ Corp? And on the proxy card, there will be a yes, and there will be a no. Right? The proxy card will say, let's say no or yes or whatever. Alright? So let's say the meeting is held and everybody votes. Those who are there present, they make their vote known. Those who are in by proxy, we know them based on the card, right? Let's say how many people, okay? We've got a quorum. Let's say how many people do we need to vote affirmatively or negatively, but let's say affirmatively. How many shares do we need to vote yes in order for the merge to take place? 1,001. If 1,001 of the 4,000 shares available vote yes, that decision is affirmative, and it will happen. Everyone got that? Did you see something kind of interesting about that number? It's a quarter of the shareholders entitled to vote. So 1/4 of the shareholders made a decision that's binding on the corporation. Interesting, huh? When we think about majority, we think that's the majority of the actual shares, right? No, the majority of the quorum, which is the majority of the shares. So only 25% of the shareholders had to vote yes in order to get this decision done. Did I lose anybody? Yeah. So that's a quorum. Once we have it, we can make decisions. If we don't, we can't. I talked about straight voting, cumulative voting, and supermajority, and just to kind of overview. Straight voting is each shareholder, their vote counts as one. Cumulative voting, a shareholder can accumulate their votes and vote them all for one person. This is usually when you're talking about directors. So again, if we've got 6 directors, and we've got cumulative voting, then I might have 1,000 shares, and I can take all 1,000 shares, multiply it by the number of directors, which is 6, and I can take all 6,000 of my shares and vote them for director number 2, who I really want to be in. That might give me a shot at getting at least one director that I like on the board of directors. That's to help me as a minority shareholder in case there's people out there who have way more shares than me, who could always outvote me if it was straight. Make sense? And then a supermajority is simply when we, in the Articles of Incorporation, decide that certain decisions won't just be a majority, it has to be a supermajority. So in other words, if we're going to vote to merge, it can't just be 51%. It's got to be 80% of us have to agree. Or, in order to merge with another company, it has to be unanimous consent. We can do that in our Articles of Incorporation. Sometimes shareholders have what's called a voting agreement. They can agree in advance. You know, if an issue comes up as to whether or not we will make widgets in China, we can all agree that we'll vote against that. And so we'll put our share certificates into a voting trust. And that voting trust will always vote no if a decision like that comes before the shareholders. We could have other types of voting agreements as well. We won't ever vote for this particular individual to be on our board anymore. We fired him once, won't do it again. Won't have to do it again. Shareholders have the right to receive information. The corporation must furnish shareholders with the annual financial statements. If it does not, what can happen to the corporation? It can be dissolved, right? The shareholders have the absolute right to inspect the shareholders list, the Articles of Incorporation, the bylaws, minutes of the meetings for the past 3 years. And they can also see minutes and records beyond 3 years if they can demonstrate a valid reason. For instance, they suspect that the company has been engaged in fraudulent activity or has been not filing its taxes properly. They want to look at that to decide whether a derivative suit needs to be filed against the director. They demonstrate that proper purpose. They can see the information beyond 3 years. Dividend. Talked about this before. Dividend is a distribution of profits of the corporation to the shareholder. It's paid at the discretion of the board. So the board, in its monthly meetings, who's in the board meeting? Board of directors, right? Who's on the board of directors? Well, usually? President, right? Usually the secretary, the treasurer, chief financial officer. And they'll be called in and they'll all meet and they'll make decisions as far as whether or not the company's profitable. If it's a for-profit company, they're going to say, yeah, we've got enough to pay dividends. So the board will declare the dividend. And the shareholders on the record date, which we talked about, right, will receive those dividends, whether or not they sell their shares after that date. Now, can a board of directors always declare a dividend? What are some reasons that might preclude them from declaring a dividend? You make any profit, right? Right. Well, no. Yes and no. If the board of directors decides that if we paid this dividend, we wouldn't have enough money in our coffers to continue running our business, can't pay a dividend. Right? In other words, if I pay out a dividend, the cash we have left is less than the liabilities that we have, such that we would in effect be insolvent. Can't declare a dividend. Right? If there's a problem with respect to paying out a dividend, if there's enough to pay preferred shareholders, but not common, we can declare a preferred shareholder dividend. Well, you can either do that, or you can not do it. And if those shareholders have dividend cumulative rights, it's going to accumulate. Or if you decide we're going to pay at least 80%, so we can pay the preferred at least 80% of what we're required to pay them, you'll do a partial dividend declaration, right? And then those preferreds, they'll get 80% of what they should have gotten. The 20% will do what? Accumulate. And then the next quarter, if there's enough to pay everybody, we'll first pay the 20% over to the preferred and accumulate it. They'll get 100% of what's due this quarter. And if there's money left over, the commons will get some of theirs, or get what's due to them. Okay? The company, instead of a dividend declaration, they can declare a stock dividend. Because that costs the company nothing. It can say, we are declaring a 10% stock dividend in lieu of a cash dividend. So everybody who owns stock, whatever that percentage is, will give you 10% more. Okay? Would I be happy with that as a shareholder? Maybe not.
Maybe.
Right? If the stock is stable, just didn't quite make a good profit this year, but it's okay. Stock dividend might be okay, right? Because now, instead of 1,000 shares, I have it's a 10% dividend, stock dividend. Instead of 1,000 shares, now I have 1,100. Right? So it might be acceptable, might not. Why do the board of directors want to always declare a dividend? And if they can't, maybe do a stock dividend.
So they can seem comfortable.
They want to make the shareholders happy.
Yeah.
Who votes them into office?
Shareholders.
Shareholders. Who votes them out of office?
Shareholders.
Why would the shareholders vote them out of office?
No money.
Because their job is what?
To
Maximize the value of the shareholder's portfolio, right?
Right.
If that ain't happening, I'm not happy as a shareholder. Right?
Right.
And remember, the board of directors, they get to set their own compensation. They get what's called a retainer for being on the board. That's an annual check that they get paid for being a board member. Plus, they get paid for having to fly in from New Jersey or New York or wherever, or Tahiti, and attend the meeting. They get paid to do that. They get paid for the day or 3 hours or 2 hours that they spend attending the meeting. Then they fly off to their next board meeting with some other company. That's the outside director. So that's pretty cushy, right?
Yeah.
Especially if you're somebody that's, say, 50s, 60s, or retired. You've done your career. And now all you do is sit on boards of directors for major companies. And so your quote-unquote job is simply getting on planes, flying from one corporation to the other to enlighten everyone with my expertise. And for that, I get an annual retainer check, maybe $50,000 for those 4 meetings that we attend, right? Maybe 100 or whatever. Depending on how big the corporation is, it could be a substantial amount of money. And I'm on all kinds of different boards. So I'm just racking up all year as a board of directors, right?
Right.
I'm not going to do anything to lose that, especially because the business judgment rule even protects my decisions. No, it doesn't fool anybody. Well, they may do that. That's why you get the treasury issue. Because they may issue the stock dividend. Okay? Savvy investor understands that it's not really increasing cash to me, it's potential maybe. But then the company turns around a couple months later and they do a treasury repurchase. No. It's a way of pulling some of those shares back out of the market because the value goes up if there's less out there. Not unless they're sold. Right? Right. It does make you front yard. Right. It's not money out of the company. You're right. Exactly. No money out of the company. So that's important. Okay. The retained earnings that the company has are still there, but there's nothing out of the company coming from declaring a dividend, stock dividend, because it's not paying out its earnings. It's just giving you a certificate that says if you want to sell this, you get the money that way. Okay. A derivative lawsuit. Let's try to cover that before our break. A derivative lawsuit, and this is not worded properly. I'm going to rephrase it. It says shareholders may bring derivative lawsuits against the corporation. They're not bringing the lawsuit against the corporation. It's for the benefit of the corporation. All right? So, if a corporation is harmed by someone and the directors fail to bring an action against them, the shareholders can file a derivative lawsuit. In other words, they can stand in the place of the harmed corporation and seek redress on its behalf. Does that make sense? A little bit.
Yeah, I do.
The book defines it as if a corporation is harmed by someone, the directors have the opportunity, or the directors of the corporation have the authority to bring an action on behalf of the corporation against the offending party to recover damages or other relief. If the corporation fails to bring the lawsuit, the shareholders have the right to bring the lawsuit on behalf of the corporation. Now, what's required in order for shareholders to do that? They have to have owned shares when the act occurred. So if I'm a shareholder and I just bought my shares today, okay? And then, because I own shares, I have a right to inspect the books. If I go back and see something that the corporation board of directors should have filed against the third party because the corporation was injured, I can't file a derivative lawsuit because at the time that happened, I wasn't a shareholder. But if I am a shareholder and I find out that in the case that I gave yesterday, where the corporation did a third-party lease or a third-party contract to buy widgets from XYZ Corporation. XYZ Corporation breached the contract. The board of directors did not enforce the contract or sue the third party on the corporation's behalf. I'm a shareholder. That means we've lost money and the board needs to take care of that, right?
That's right.
If I'm a shareholder, I'm obligated, or not obligated, but I have the authority or the right to go to the board and say, board of directors, you need to, on the corporation's behalf, file a lawsuit against this third party to recover the damages to the corporation. If the board of directors either rejects that request or fails to do anything for 90 days, then I, as a shareholder, can sue the company on behalf of the corporation, okay? Not on my behalf, on behalf of the corporation, because I have to represent the interests of the corporation. With me so far? If the lawsuit is successful, and say a judgment of $2 million is obtained against the third party, that money goes back to the corporation's coffers. Derivative lawsuit. I, as a shareholder, filing on behalf of the corporation. Right? Another way it might work is, let's say the board of directors does some just egregious act that damages the corporation. let's say the board of directors in our corporation, we are authorized to sell real estate. Okay? And the board of directors decides to sell commodities. Is that an ultra-virus act? Yes? What's an ultra-virus act? An unauthorized act by the corporation, right? So the board of directors commits an unauthorized act of selling commodities when I, as a shareholder, bought shares because you sell real estate, not commodities. I can go to the board and say, hey, stop doing that. Because we've lost $100,000 because of your action. The corporation has lost $100,000. I, as a shareholder, have ostensibly, potentially lost dividends because of that, right? The board doesn't do anything. I, as a shareholder, can file a derivative lawsuit against the board of directors, saying, in essence, I'm suing you on behalf of the corporation that's been damaged. If successful, the $100,000 will come out of the board of directors members' pockets. And it will go into the corporation, and we go forward. I'll show you how that works in this case. Yeah, let me go.
Who actually is paying the attorney fees? Is it on contingency?
Here's the attorney fees. Usually it's not contingency. But the shareholder will get an attorney to file this derivative lawsuit. If the lawsuit is successful, the court will award the attorney's fees to that shareholder. So, shareholder, you're the attorney, I'm a shareholder. Tamiko, I want you to represent me in a lawsuit against the board of directors of my corporation. A derivative suit. You go ahead, you file a lawsuit, we win. We get $100,000 to the corporation. The court is going to also award me attorney's fees for having to pay you $10,000 to do the work.
Okay.
The board of directors is going to have to pay that out of their pocket. And the $100,000 judgment out of their pocket. Derivative lawsuit. That answer your question?
Yes.
Yeah.
What's their pocket?
Their pocket.
Well, I mean,
Not the corporation.
personal accounts, the entire board of directors.
Yeah.
Every single person. So you name,
All
do
together.
you have to name them somewhere in the actions, how to make sure that they get money from them?
Here's the key. You do name them personally. Here's the key. When you're on the board of directors,
Yes.
you're going to have liability insurance, right? Hopefully cover stuff like that.
DNR.
But what happens is, to keep from being liable to begin with, because even if I have insurance, I don't want to have to press for it, do I? Because
Right.
what happens to my premium?
Goes up.
Right? So, as a board of directors, here's what I do. Say, because the majority vote of the board of directors is what rules, right? So, if there's 7 directors, 4 vote in favor of doing this act, and 3 don't, say I'm one that realizes it's not a good act to do, and I vote against it, but 4 people voted for it, it's an act of the board. Right?
Right.
Even though I disagree, I only have 1 vote. If 4 agreed, it's a majority decision of the board. Board members cannot act individually. Period. They can only act as a board. And they only act by voting for or against. So here's how I protect myself. I realized this was an ultra-virus act. I voted against it, but it succeeded anyway. What do I have to do to prevent liability? I got to resign from the board.
Okay, so you can't bring that action as a board member.
No,
You just got to get out.
you got to get out of the board. You just resign because it's your act. You're a member.
You can't bring
Your
that
act.
Okay.
All right. What I can do though is say, all right, this passed. I'm against this, and this is serious to me. I resign from the board. It's my written resignation. Effective now.
You write in why
Let
you
me finish. I have resigned from the board. Therefore, if a derivative suit comes across, I'm not going to be liable because I resigned. I voted against it, and I resigned. That cost me something, right? That's how important. That cost gets me out of being liable for that decision. Or, let's say it's not so serious, but I still don't want to be potentially liable. I can write a letter expressing the fact that I disagree with this decision wholeheartedly. Alright? That might make me not liable. But I can get out of liability if the decision is so bad that I don't want to be responsible for it. Okay? Somebody had their hand up. Did that answer your question?
Yeah, I just have one more question. So when you're reading this derivative lawsuit, which shareholders typically bring those lawsuits?
The majority shareholder.
I mean, is there like a group of people who usually figure it out and then contact the rest of the shareholders?
Yeah, that's another reason why the list has to be available.
Okay.
So you have access to the other shareholders. I can get together and see if there are others who think the way that I think, and we can pool our money so that I'm not the only one paying the attorney fees, right? Because it's going to benefit all of us, right? So I can say, hey, Angela, we both own shares in XYZ. I don't think that what they did was right, right? The law says you sell real estate. That's why I bought in. You're now doing commodities and lost $100,000. That's a ultra virus act. Let's get together and get an attorney to sue. We'll split the cost.
And is the suit always brought against the board?
It's brought against whoever has agreed to the corporation.
Okay.
All right, let me get to Disney and we'll talk about the board. But in this case, it was the third party who agreed. The board just didn't do anything. Okay? I can go directly and sue these guys because they're the ones who injured the party, the corporation, right? If I win, money goes to the corporation. If it's the board that did something, the Ultra Virus Act, then there's no third party to sue, right? But the board. So I'm going to sue the board on behalf of the corporation. Derivative lawsuit. Got it?
So the board get in trouble on that side too?
They could. They could. Most likely what's going to happen in this case,
Not gonna vote
next
back
time
in.
we do the election,
They ain't coming back.
Yeah.
right?
Okay.
Possible. Okay. Let's take our break till 10:30. We'll come back. Finish up.